1:30 item. This is a public hearing, consideration of appeal PL 26-12 of Planning Commission's approval of major use permit PL 2513 for UP 21-15 Rancho Lake LLC. Location is 19955, 19986, 20110, and 22222 Grange Road in Middletown, with the APN numbers being 014-290-08, 014-300-02, and then 03, and then 04, with the appellant being Peter Luchetti. And we have our Community Development Department here. The first order of business is that we're going to need to swear in witnesses on all sides. So all of our staff, anybody from the appellant and any of their witnesses, anybody that's going to testify needs to stand and raise their right hand, including anybody online that may be a witness. You should have Eric Smith online. Do we have Eric Smith? And he's got his hand raised?
Yep. Eric Smith's online with his hand raised. All right, everybody else with your right hand raised, do you solemnly swear that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth? Thank you. Oh, and we have Autumn Carsey online too.
Is she a witness? Okay. All right, then in this case, we're going to start with the Community Development Department staff to present to us.
Thank you.
What's that?
Maria Turner, Community Development Director. Our presentation will start shortly. I will turn this over to our Senior Planner, Mary Claiborne.
Good afternoon, Supervisors and Chair. My name is Mary Claiborne. I'm a Senior Planner with the Community Development Department. Today for consideration is PL-26-12, Appeal of Major Use Permit PL-25-13. This item was continued from April 21st, 2026. The appellant, applicant, and their counsel are present in chambers or in Zoom. On January 8th, 2026, the Planning Commission approved a major use permit, PL-25-13, for commercial cannabis cultivation of 19.6 acres of outdoor canopy and a Type 13 distribution self-transport only license. The appeal, PL-26-12, was filed by the appellant on January 12, 2026. The appellant raised concerns specific to substantive CEQA violations and inadequate environmental review, land use incompatibility, general welfare, and reservation of rights. The site is located approximately 4.5 miles east-northeast of Middletown. The closest community growth boundary is approximately 1,450 feet southeast of the project site. The parcel is split zoned agriculture and rural residential. However, cultivation activities are proposed on the land designated as agriculture. The surrounding land uses are rural land, agriculture, agriculture preserve, rural residential, and open space. The proposed features for the permit request include up to 19.6 acres of outdoor canopy within a 34-acre cultivation area, 5 6,000 square foot harvest storage and staging engineered membrane structures for seasonal use, 2 120 square foot sheds for chemical, pesticide, and hazardous material storage, 1 120 square foot shed for office and security use, 20 5,000-gallon water storage tanks for irrigation and dedicated fire suppression, an employee parking area with 14 standard spaces and 1 accessible space, an on-site portable accessible restroom and hand washing facility, 6-foot galvanized woven wire perimeter fencing with metal gates equipped with padlocks, security cameras, and internal roadway improvements. The proposed location for Cannabis Canopy is located in a flat valley. There is one perennial Class 1 water course, an intermittent Class 2 water course, and several Class 3 water courses on site. All setbacks from water courses have been identified. No surface water diversion is proposed. A wetland delineation was not required for this project due to avoidance by design. The site has been used for continual agricultural operations, and the total parcel size is approximately 1,627 acres combined. The project parcel has been improved with internal compacted dirt and gravel access roads, a residence, agricultural accessory structures, and 2 groundwater wells. AB 52 tribal notification of the project was sent to tribes with Aboriginal territory in and around County of Lake. Tribal comments were received from the Hebemetal Pomo of Upper Lake Tribe, deferring to Middletown Rancheria. The Community Development Department did not receive a formal AB 52 tribal consultation request for this project. However, the applicant, Rancho Lake LLC, has voluntarily entered into a cultural resources monitoring and treatment program with the Middletown Rancheria. Regulations reviewed for compliance include the Lake County General Plan, Middletown Area Plan, CEQA Guidelines, Department of Cannabis Control Regulations, and the Lake County Zoning Ordinance. Project Analysis, the California Environmental Quality Act. The CEQA environmental determination for the project is a mitigated negative declaration adopted by the Planning Commission on January 8, 2026. All identified impacts are reduced to less than significant with mitigation measures incorporated. Public comment period occurred from November 1st, 2023 through November 30th, 2023. Impacts identified include aesthetics, air quality, biological resources, cultural resources, hazards and hazardous materials, hydrology and water quality, noise, tribal cultural resources, and utilities and service systems. Based on the analysis provided in the ISMND, staff found the project to be consistent with all applicable codes and requirements. Points of interest, project scoping. The Rancho Lake project application was submitted to the Community Development Department on April 5th, 2021. To ensure compliance with setback requirements from waterways, the existing PG&E utility easement, and to address multiple operational considerations and concerns, the scope of the project was revised, resulting in reductions to both the cultivation area and the canopy size. The final proposal was revised from 73.4 acres to 19.6 acres of canopy. Additional points of interest, hydrology and water resources. Puda Creek, a perennial Class 1 watercourse, flows through the northernmost portion of the project parcel. Crazy Creek, an intermittent Class 2 watercourse, flows into Puda Creek. Multiple unnamed intermittent Class 3 watercourses flow through the project parcel and into Puda Creek. The project meets 150-foot setbacks from Puda Creek and 100-foot setbacks from the other creeks and watercourses. According to the Hydrogeologic Assessment Report, the proposed cultivation operation has an estimated annual water use of approximately 49.2 acre-feet per year. The recharge rate is estimated to be approximately 793.2 acre-feet per year. The report concluded that the site can sustainably produce the water needed to meet the project demands without causing overdraft conditions. The drought management plan submitted by the applicant identifies best management practices per the State Water Resources Quality Control Board's Cannabis General Order. The General Order conserves water resources during normal times and in times of drought. The applicant intends to reduce their outdoor canopy area and water usage by approximately 10% during declared drought emergencies. Points of concern that were raised by the appellant: hydrological impacts, traffic impacts and evacuation, inadequate biological surveys, and failure to comply with safety standards. The certified hydrogeologist, Lee Hurwitz of Hurwitz Environmental Services, provided information that Puda Creek and the project's well do not have direct interference. The radius of pumping influence suggests that groundwater well would not have a direct effect on stream flow. This project does not involve water rights or surface water diversion. Traffic impacts and evacuation. The project's internal traffic analysis indicated an average of 24 daily trips with up to 40 trips during peak season, which does not meet the CEQA threshold of 110 or more trips to require a detailed traffic study. A formal traffic study was not recommended for this project in accordance with CEQA guidelines. Staff was directed to reach out for agency comment to the fire district for emergency evacuation. The fire district deferred to Lake County Sheriff's Office of Emergency Services, or OES. OES responded to the request for comment, which is in Exhibit A9 to staff's report. Staff recommended that the conditions of approval be amended prior to project approval at the January 8th hearing to include a condition from Lake OES as a result of the agency comment received. Inadequate biological surveys. The adopted initial study mitigated negative declaration includes mitigation measures specific to biological resources as identified within the biological surveys and agency comment received during the review period. According to the CEQA analysis, impacts relating to biological resources would be reduced to less than significant with mitigation measures Bio 1 through Bio 5 incorporated. These mitigation measures are reiterated within the project's conditions of approval. Bio 4 requires pre-construction surveys for special status plants and animals, and Bio 5 requires pre-construction surveys for nesting birds. Failure to comply with safety standards. Fire mitigation measures were also identified within the adopted ISMND and shall be implemented in accordance with Public Resource Code subsection 4290 and subsection 4291 fire safety standards, including road width requirements, appropriate turnarounds, gate access, defensible space creation, and the installation of water tanks designated for fire suppression. Internal gates and roadways shall meet the requirements of PRC 4290 and will be equipped with Knox box to ensure rapid access for emergency responders. These improvements will not occur until project approval. Additional points raised by the appellant: land use incompatibility and general welfare, threat to organic certification, pesticide drift, inadequate buffers, absence of engineered odor control, inadequate setbacks conflict with residential use, and prime farmland incompatibility. Pesticide use in Lake County falls under the regulatory jurisdiction of the Department of Pesticide Regulation, with oversight at the local level by the Agricultural Commissioner. The Agricultural Commissioner provided agency comments noting that the operator must obtain a pesticide operator identification number in order to purchase and apply pesticides. Additionally, the operator must acquire a private applicator certificate to train employees involved in pesticide application. It is not uncommon for conventional and organic farmed properties to exist side by side. However, pesticide applicators have a responsibility when making applications to not allow products to drift or to continue making an application when weather conditions would favor potential drift. The applicant plans to dry cannabis within engineered membrane structures for seasonal use. The structures do not include the use of air filtration equipment due to being temporary in nature. These structures will be constructed in July of each year and deconstructed in December. No permanent foundations for these structures are proposed. Odor control measures are mandated for permanent greenhouse structures located within the farmland protection zone. Since the project involves outdoor cultivation under full sun, the use of odor filtration equipment is not required. The closest off-site residences are approximately 900 and 1,000 feet from the project site respectively. The proposed location of the cannabis canopy exceeds the 200-foot setback requirement for off-site residences. Prime farmland incompatibility and inadequate buffers. The project will utilize approximately 40 acres, which is 2.5% of the total 1,627-acre property. The remaining land will continue to be used for grazing and agricultural purposes. The proposed outdoor commercial cannabis cultivation activities are agriculture in nature, such as planting crops and harvesting product, and align with existing land use patterns, surrounding uses, and applicable zoning regulations. The Lake County Board of Supervisors has not designated the project area as a farmland protection zone, or FPZ. The nearest FPZ land is situated in the Lower Lake area along State Highway 29, approximately 10 miles as the crow flies from the project site. Staff must analyze projects for conformance with existing code requirements and regulations. The project meets all required regulations related to development and siting and is also consistent with the Lake County General Plan, Middletown Area Plan, Lake County Zoning Ordinance, CEQA guidelines, and Department of Cannabis Control regulations. Staff recommends the board deny the appeal, upholding the January 8, 2026 Planning Commission's approval of the project. And I'm available for any questions or comments you may have.
Okay, is any further from the community development at this point? No? So then we would go to the appellant. And who's going to be presenting?
I have several folks with me. I have Peter Luchetti, Eric Smith, and Ryan Crawford.
Okay. Okay. Go ahead and proceed, sir.
As my counsel, Mark Hirsch, indicated, I'm Peter Luchetti. To be clear, in Mary's presentation, I'm representing 276 Rancho LLC, which is a property that's owned by my family. So I don't own it myself. It's owned by my family through the LLC. So I just want to make sure we correct that for the record. It's 276 Rancho LLC. I want to thank the board for your time and consideration of our appeal. We take your time and effort and resources quite seriously, and we'll try to be expedient in our comments and be as efficient as possible. Before we get into the details of our response to the presentation you just heard and our concerns about the mitigated negative declaration, I want you to get to know us a little bit better. So I'm going to make 2 or 3 minutes of comments about our background and our history and the ranch itself. 276 Ranch is a 56-year family-owned operation in Middletown area, directly next door to the ranch that you just heard about, the Comstock Ranch. And in those 56 years, we've never missed a year of producing beef cattle. In fact, in California, we produce beef cattle in 3 locations, east of Santa Barbara and Cuyama, and Marin County at the Mount Burdell Reserve, and here in Lake County. So we produce about 500 head of cattle a year. But we've never missed a year of production. In 56 years, including the Valley Fire, which was devastating for the ranch, as it was for the Comstocks and several other people in our area. A very regrettable and difficult time period, I might add. We lost about $3.5 million of infrastructure in the fire, 3 homes, 2 historic barns, our main equipment shed, livestock. But we kept the cattle moving and we kept the operation alive. We didn't walk away from Lake County. And this is, I think, one of our main points. 10 years ago, we transitioned the ranch to certified organic. We are certified organic, despite what you might have heard. It was difficult to do this, very, very hard, a struggle to make your ranch comply with all those rules and regulations. And, several years before the books turned a profit, but as many of you who've been to the grocery store recently might know, beef's up about 450% in price in the last 10 years. So we're now very profitable. And I'm proud to say solidly profitable. I'm proud to say we're able to pay an insurance bill that's 400% more than it was before the Valley Fire, regrettably, but we're able to pay it. In addition, we make our payroll to our employees. We pay our property taxes. We fund improvements, and we're really proud of what we've done. You know, when we rebuilt the ranch, we invested $5.5 million in rebuilding our ranch. $3.5 million came from insurance, and the balance came out of our pocket. And to get the $3.5 million insurance, I had to go through a 3-year lawsuit with the insurance company. Another terrible thing to have to do after the Valley Fire, but we did get the money. And we did invest it. We didn't walk away from Lake County. We invested it back in Lake County. And this is the context of the appeal. We are not in opposition to the cannabis industry, and we're not in opposition to the idea that the Comstocks might grow cannabis on their property, to be clear. There's a version of a permit we could accept. And we're very open to that conversation. It's a request for the board to protect what's already here, a multi-generational certified organic ranch on prime farmland. No, it's not FPZ, although I think it should be. I don't think a cattle rancher should be prejudiced versus a grape grower. In the South, a cattle rancher in the South County should not be prejudiced over a grape grower in the North County in terms of protecting traditional agriculture. And that, again, I'm not opposed to cannabis. I'm trying to make the things coexist together in a thoughtful and orderly way. We need to get our story straight relative to a 19.6 acre commercial cannabis cultivation directly over the fence line. So there's a 100-foot setback, but that's not much. You know, our organic land and 110 acres of irrigated pasture, you can see in the picture up there is the green space up there is directly over the fence line. There are several topics of concern with the MND, the Mitigated Negative Declaration from Rancho Lake LLC and the Comstock family that we'd like to talk about. And we have experts here today to shed some light on our perspective on the inadequacies of the MND and what we need to do to take corrective action. They include water supply and aquifer hydrology, odor control and pesticide exposure, what you just heard about from Mary, the wildfire risk, Section 4290 issues, and some biological issues. They all figure prominently in our appeal. In closing, I'm asking the board to put appropriate protections in place for traditional agriculture in Lake County while respecting the Comstock's right to grow cannabis. To find a solution, in effect, that mediates this so that we can coexist together and enjoy a very, very, I think, superior relationship we had with the Comstocks for 56 years. But it has been put under great strain by this particular conflict that we're having that I would like to see resolved. I don't wish to have conflict with the Comstocks. I don't speak disparagingly about them. We have great love and great care for the Comstocks for 56 years and had a wonderful relationship with them and hope to have that going forward. With this introduction, I would like to turn it over to Martin Hirsch, my counsel. He's going to organize the discussion of the experts that will talk about the issues around the MND, if I understand it correctly.
Thank you, Peter. Thank you, supervisors. I'm Martin Hirsch. I have the honor of representing Peter Luchetti and 276 Ranch. We're here today simply because it's our position that the MND is insufficient and that this project should be processed on an EIR for the reasons that have been talked about by staff and that Peter touched on. Concerns about odor and pesticide drift, fire safety, our feeling that the biological and the hydrological studies were inadequate. As a reminder, I'm sure you all have heard this before, but I want to touch on some of the relevant CEQA guidelines that I think provide the principles in play for why you will hear that an EIR is required for this project. So the basic CEQA rule is that if there is substantial evidence in light of the record as a whole that a project may have significant effect on the environment, then an EIR should be prepared. If a lead agency is presented with a fair argument that a project may have a significant effect on the environment, the lead agency shall prepare an EIR even though it may also be presented with other substantial evidence that the project will not have a significant effect. And that leads into if there is a disagreement among expert opinions supported by facts over the significance of an effect on the environment, the lead agency shall treat the effect as significant and shall prepare an EIR. Basically meaning if there's a difference of opinion among the experts, that means that there is an issue of significance necessitating an EIR. So the first issue that I want to call up one of our experts to discuss is the hydrology, and that's one where I think there is a significant difference of opinion between the experts. So to speak on that, I'm going to ask Ryan Crawford, who's here from GHD, to address you all.
Good afternoon, supervisors. I guess I'll introduce myself first, although I know I've been in this courtroom a few times. Thanks for having me back. I've worked in the water resources engineering field for over 20 years. Lake County, Humboldt County, Sonoma, Napa, the North Coast. I've worked specifically in the Coyote Basin. Our company actually engineered and built the Hidden Valley Lake CSD. I've personally been monitoring and doing pump tests and municipal groundwater studies for the CSD and other entities within the Coyote Basin there. If I can step back just for a second on the big picture, if that's okay, and I'll zoom into the site. Take me just a minute. Coyote Valley Groundwater Basin, is most people here are aware of, is that little closed basin with a lot of water flowing through initially during the wet season from Puda Creek, and then it will dry out or get really dried out or run dry, Puda Creek at least, during droughts, including the last recent really bad one. Groundwater, zooming into some of the sites, this particular site is at the very southern end of the groundwater basin where it pinches and is completely bound by hard rock. So it thins and it's bound by hard rock right there. The state Department of Water Resources has data on this groundwater basin from 1950 all the way to they stopped in 2010. And the CSD has continued monitoring their wells and monitoring wells, including on the Luchetti property since that time. Long-term trends since 1950 show it's generally declined almost 10 feet over that time. You can look at a trend, it just looks like it's going down 8+ feet. Fluctuations of groundwater between a wet year and a drought year are about 30 feet in difference. That's depth of water from the surface, could be 10 feet below the ground, and then on a really bad drought like the last one we had, it's 30 feet below the ground or more. And so I think, in my personal opinion, after putting transducers in Luchetti's wells in 2024 for the spring, the summer, and the fall, to see what his wells were doing, what the monitoring wells nearby were doing, and if they interacted with each other or caused interference, even just on their property. And I believe he reached out to the neighbors to see if they would participate just in trust, because this is sort of public trust, groundwater trust. And they declined, so we unfortunately don't have the data to see even if their wells were interacting at all, which I think is a general thing one would do to prove that there is an impact going on between uses and groundwater uses. Groundwater use on this scale can be tricky without real data. The data provided, with all due respect to the other consultancy, it was based on a 6-hour pump test simulation on itself. So pumping from their wells that they put in, but not using other observation wells to do physical distance drawdown testing. So in most of the hydrological cycle that we had transducers in the Luchetti Ranch wells, even when they were pumping in use for their normal year, it was sort of a normal-ish rain year for 2024, they do even on-site interact with each other and drop water levels between each other. So I have a hard time imagining that just over the fence, they wouldn't have some sort of material impact to the groundwater levels within the Luchetti Ranch wells. So I'm open to questions or anything along those lines, or if I missed anything, would you like me to, I could go into greater detail on everything I spoke about, but I want to be succinct too. And
I'm not seeing any questions right now.
Okay, and the next topic that I would like to address is the, as we see it, the inadequacy of the biological study. Eric Smith should be online. He's reviewed the biological analysis and has some comments addressing the inadequacy. Basically, in that it fails to adequately address impacts to candidate and proposed threatened and endangered species. The botanical surveys that were performed were conducted during a period of exceptional drought. The survey performed did not cover the entire project area, and the survey results are out of date. So I believe Eric is prepared to address that in greater detail.
Go ahead, Eric.
Thanks, everyone. Can you hear me?
Yes.
Great, thank you. Thanks to the staff and the supervisors and the chair. So as Martin said, I want to talk about the biological documentation. I'll say I have 15 years of experience doing surveys for the species and resources in question here in Central California, but I want to state for the record that the biologists who did the work for this project are very well qualified. I'm not here to impeach their credentials. I'm not arguing with any of the facts that they wrote in their report. In fact, I'm relying on the facts as they lay them out. But what I want to point out is that according to their own reports, there are some things they didn't look at, but which I think they do deserve to be looked at. So the reports are incomplete in several ways. They don't address two different candidate endangered species. The surveys didn't cover the whole project area, and the surveys don't meet the required standards for rare plants or for wetlands waters. The surveys were conducted in early 2021, and bad timing just a few months after the surveys were done, Crotch's bumblebee, which is a candidate for listing under California Endangered Species Act, was then found a few miles away from the site. It's since been redocumented a bunch of times in the area, but because it hadn't been found yet when the documents were prepared, it didn't come up in their record search, and it's not even discussed in the documents in the Biological Resources Report in the ISMND. I don't know that this species is present on the project site, but it does deserve to be examined and addressed in the documents. As a candidate for listing, it gets full coverage of the California Endangered Species Act. Second, another element of bad timing is that the documents discuss northwestern pond turtle, but it wasn't until 2023 that northwestern pond turtle was proposed for listing under the Endangered Species Act. The biological report says pond turtles are present in Putta Creek on the property right next to the project site. And it also says that they dig their nests and lay their eggs up to 1,600 feet from the water's edge. Problem is, the ISMND only has that 100 to 150 foot setback from the stream for ground disturbance. The entire cultivation area is within 1,600 feet of a stream. So according to the project's own documents, turtles could be nesting anywhere in the cultivation area. The ISMND gives a measure for pre-construction surveys, but a team of turtle experts has recently found that pre-construction surveys, which are just a walkthrough on the ground, aren't able to find turtle nests because they're buried to hide them from predators. In order to adequately protect turtles from basically getting their nests destroyed by disking and grading, there needs to be something more intense than a pre-construction survey. Third item that's unfortunate about the timing of the bio studies is that they were done in 2021, which you may recall was an exceptional drought year, the highest level of drought rating, only 40% of average rainfall. That makes it very hard to identify plants, especially annual plants. The protocols for plant surveys say that if you have a drought year, you should do an extra year of surveys. and or you should go confirm that the plants are in fact blooming at reference sites. That didn't happen in these surveys. They didn't use reference populations. The other thing the protocol says is that in addition to doing multiple years, if you have a bad year, that surveys age out after 2 or 3 years. These surveys are 5 years old, so one way or another, it's pretty clear that additional surveys are needed in order to establish whether there are rare plants on the site. Also, of course, if you want to detect species, you need to search your entire site. The project survey map presented in the reports show that the botanists surveyed the entire site in February, but then they didn't survey when they went back in April and June. Not a lot of plants are blooming in February, so you can't say that you've done a complete botanical survey of the site if you didn't do the entire site in the spring and summer surveys. I did want to say that staff mentioned that the ISMND has pre-construction surveys for protected species, and this is just a technical thing, but pre-construction surveys are not the same as protocol or planning surveys. Planning surveys follow established protocols, and they're timed when the species can be detected, and they take multiple visits over weeks or months. Pre-construction surveys are a walkthrough right before work starts. The whole reason that we have those protocols that the agencies wrote for us is that you can't just walk through on any arbitrary day and see everything. So pre-construction survey is not sufficient to replace the planning surveys that need to be redone. And then if I've still got time, I just want to say about wetlands and waters that, as staff mentioned, the project's biological documents are very clear that they did not do a wetland delineation. The reason that's a problem is that first, they have their required setback from streams, and you can't say how far you are from a stream if you don't do a delineation to say where the stream is. The second issue is that they say that a wetland delineation isn't needed because there are no wetlands on site, but the way you establish whether there are or not wetlands is to do a wetland delineation. That's the one process that's approved by the regulatory agencies, Army Corps and Water Board. So, just looking at the aerial, there are places that you would look at and say, is this a wetland? I'd like to know, could you do a wetland delineation? Those are the major factors. Thanks for your time and attention. Do you have any questions for me?
Doesn't appear that we do at this point. Thank you.
You all.
Thank you, Eric. The next topic I want to address is odor and pesticide drift. We retained an environmental scientist who holds a PhD in that field, Dr. Mark Cram, who unfortunately couldn't be here. He just returned from an overseas trip a few days ago. So I will try to summarize his opinions. It's pretty typical, or it's pretty technical and dense. So please bear with me. Dr. Cram, as I said, he holds a PhD in environmental science. He has studied approximately 40 cannabis grows throughout the state of California, specifically measuring odor and pesticide drift. And he's come up with essentially, as I understand it, odor is chemical compounds that are in the air that basically float, and we sense them and receive them as smells. So he's been able to measure these chemical compounds and come up with a level of exceedance where if the chemical compounds are between 20 to 50 parts per billion by volume, that's where humans will pick up that skunky aroma of cannabis. And through his studies, as well as other studies in the field, it's his opinion that a cannabis grow of this size could be detected by smell, the odors, between 1 to 2 miles away from the project area. And again, that's based on the 20 to 50 parts per billion by volume of the chemical compound, which is primarily micrine. It's also his opinion that the fertilizers, fungicides, pesticides, and herbicides used on the site will also be picked up and drift onto the neighboring Luchetti property. And basically he says that this size, any cannabis grow, but especially a cannabis grow of this size, sort of is emanating chemicals into the atmosphere, the odor chemicals, as well as any pesticide and that sort of thing that is sprayed on the site. And those chemicals will carry a much greater distance than what the project applicant indicated based on, I think they used a study of a 1 acre grow, which is obviously not an apples to apples comparison to this project. It's his final conclusion that as a result of the odor and pesticide drift that will travel a much greater distance than what was indicated by the project documents, that Mr. Luchetti and 276 Ranch is likely to suffer harm by the deposits of those chemicals onto its property. I also want to point out that the mitigation measure stated in the MND, which is that in the event of a drift occurrence, a complaint could be submitted and that there would be a follow-up investigation. That doesn't protect from harm. A follow-up investigation means that the harm has already occurred. So that's, in my opinion, not an adequate mitigation. Finally, touching on fire safety, Public Resources Code Section 4290 requires access roads in state responsibility areas to be at least 20 feet wide. Here, the road in question is 16 feet in width, so the basic math doesn't add up there. The road is not wide enough. And added to that, the road is not just used by this project and 276 Ranch. It's also used by the U.S. Coast Guard facility, the Gwinnett Valley and Noyce Ranch properties. It was also indicated in the Gwinnett Valley Resort EIR that approximately 4,511 vehicles would exit over this road in the event of an emergency. So the cumulative impact of not just this project, but the Gwinnett Valley Resort project should have been studied, and that's obviously factoring in the Gwinnett Valley Resort project that exceeds the threshold of significance when taken together. So with that, I conclude my remarks. Thank you. Unless there are any questions, of course.
Does the board have any questions for the appellant's testimony at this point? Go ahead, Supervisor.
I don't have a question for the appellant. In fact, I should have asked this question, but I'm going to ask it publicly to Mr. Guintavano. We've been provided information about a petition that was filed in the courts. It's got the appellant's name on it. It's got our name on it. Like, what is our abilities today? And do we ignore that and continue on with this? I feel the need for guidance to better understand how we don't I don't know what the word is that I'm looking for, but put ourselves in a trap of saying things today that would just be used against us when we already have a claim filed against us at this moment in time. I believe it's got the County of Lake, the Planning Commission, Board of Supervisors on that, and I just wanted to at least, I feel it's like an elephant in the room that needs to be discussed to help guide us on how to engage in this discussion.
Thank you, Mr. Chair. So those are two separate proceedings and one proceeding at this point, the court. There is no bar or prohibition or injunction on your board to proceed with this appeal hearing at this point in time. And to the extent that any reference would be made to arguments or documents that were filed in court or that were presented in court for your board's consideration for purposes of this appeal, your board, the suggestion here would be to essentially categorize those arguments, if they are going to be presented here, for your board's consideration, much like any other appeal, based on the findings that were presented in the staff reports as made a part of this appeal for a major use permit. And you see that in Exhibits A and A1, I believe, and those are in reference to the December 11, 2025 staff report and the January 8, 2026 staff report, and the findings that were made in those reports.
Okay. And I do agree that there's a separation, but we all received information. It's in one of the attachments as well, where within that attachment, the court case was attached to it. So it's hard to not separate when it's part of the attachments that we were provided in order to prepare for today.
Thank you. Anything else at this point? No. Okay. Yeah, go ahead.
Well, I have some comments when we're ready for
Okay.
our regular comments.
So if you're concluded, then I'm going to move on to public testimony
Thank you.
at this point. So numerous people were sworn in. Do we have any public testimony? Who wants to go first? Hang on one second. I believe this be limited to 3 minutes on the public or not?
Well, thank you, Mr. Chair. So with testimony, it wouldn't be
No limit.
no limit. And your board may want to also just confirm and check if the witnesses
sworn in.
here, there would be witnesses on behalf of the applicant itself, since we've already covered both two
Right.
sides.
We've heard from both sides, but we haven't heard from the applicant yet.
Would you like to, I can sit down if you prefer.
Okay, does the applicant want to provide any testimony before we hear other testimony? Yes. Sounds like it, so come forward.
Good afternoon, Chair, members of the Board of Supervisors. My name's Timothy Kasuni, and I am counsel for the applicant, Rancho Lake Incorporated and Comstock Ranch LLC. This has been a very long process. There will be a number of other testimonies from other people with the applicant's project team. I want to just give you a generalized legal framework for how we address a mitigated negative declaration and whether or not an EIR is required, which is the appellant's contention. I've submitted a letter for the record dated May 14th, 2026. It is a 12-page letter that lays out the legal framework why there is more than substantial evidence to support the mitigated negative declaration. I'm not going to repeat that letter, but I think it is, if there are any questions in that regard, it could be referred to. I want to also address a couple of the points made by the appellant's counsel. The question before this board is not whether someone disagrees with the project or whether hypothetical impacts are conceivable. The question is whether substantial evidence in the record supports a fair argument of a significant environmental impact that was not mitigated to less than significance. Here, the county has substantial evidence supporting the mitigated negative declaration, and the appellant has not presented substantial evidence to the contrary. The appellant explicitly relies on CEQA guidelines 15064 subdivision G, arguing that because Ryan Crawford disagrees with the project hydrologist, the county must prepare an EIR. The existence of disagreement alone does not automatically trigger an EIR. CEQA requires substantial evidence supporting a fair argument of a potentially significant impact. The county has substantial evidence supporting its conclusion that groundwater impacts would be less than significant, including a site-specific hydrogeologic assessment, basin-wide groundwater evaluation, recharge analysis, and empirical pumping data. Importantly, the appellant's expert does not provide actual measured evidence showing that the project will significantly impact neighboring wells. Instead, he largely speculates that impacts may occur during drought conditions and criticizes aspects of the methodology. The appellant does not identify any evidence demonstrating that the methodology used is unreliable or that it produces erroneous conclusions, nor does the appellant present an alternative analysis based on site-specific data showing that significant impacts would occur. Absent such evidence, the appellant's critique amounts to disagreements with the methodology, which does not constitute substantial evidence. And on that point, I'd refer specifically to page 5 of my May 14th, 2026 letter. There's just a couple sentences I'd like to read. In that letter, I state, the appellant does not identify any evidence demonstrating that the methodology used is unreliable or that it produces erroneous conclusions. Absent such evidence, the appellant's critique amounts to disagreement with methodology, which is not substantial evidence. And I'm citing a seminal case, Laurel Heights Improvement Association versus the Regents of the University of California. It's a California Supreme Court case. As for biological resources, the record reflects multiple biological surveys conducted across different dates in 2021, plus a more recent pre-construction survey conducted in April 2026. The 2026 survey confirmed that no special status species or habitats had moved onto the site. If we speak on this, which I am, I would like to emphasize that the site has long been actively disturbed agricultural land. The habitat quality was evaluated by qualified biologists, and no responsible wildlife agency objected to the analysis. On this point, and at this time, I'd like to let the board know that there is also appearing by remote an attorney as part of the applicant's team, Kendra Hartman. Might be appropriate for her to make an introduction. I believe she did attempt to raise her hand to be sworn in. If the record is not clear on that, I'd like the record to be clear now that she is here. She can raise her hand and take the oath, but I'd like to make the introduction to Kendra. Once Kendra has made her introduction, she might have some additional comments. I'd like to have one of the other of the applicant's team proceed with their testimony. Thank you.
Johanna, was Kendra sworn in? What was that?
If I may.
Yeah, go ahead.
Thank you, Mr. Chair. So if Ms. Hartman is submitting arguments as an attorney on behalf of the applicant, then her those arguments would not have to be sworn.
Okay,
would not be
so she
sworn.
needs not take an oath. She's making arguments as counsel, but it's, yeah, I would like her to introduce herself, and when she's done, I'll proceed with the next member of the applicant team.
Okay. Kendra?
Yes. Can you hear me?
Go ahead.
Hi. Hi, Chair and members of the board. I won't repeat everything that Mr. Kasuni just presented you with, but I just want to re-emphasize that the issue before the board is not whether there's opposition to the project or whether someone can speculate that impacts are theoretically possible. Under CEQA, the question is whether substantial evidence in the record supports the fair argument that this project may cause a significant environmental impact that has not been mitigated to a less than significant level. And here, the county properly conducted an initial study, and they imposed mitigation measures, consulted with responsible agencies, and adopted a mitigated negative declaration, which is supported by substantial evidence in the administrative record. With respect to the groundwater and hydrology, the record contains site-specific hydrogeologic assessment, which evaluated groundwater availability, recharge, aquifer behavior, potential impacts to neighboring wells and to Puget Creek. And the analysis concluded that the aquifer system is capable of sustaining the project's demand without causing significant impacts. The record also contains real-world empirical pumping data showing that nearby wells have experienced substantially greater extraction volumes than this project proposes, with only minimal drawdown and rapid recovery. The appellant criticizes aspects of the testing methodology and speculates about drought conditions, but speculation and methodological disagreement do not constitute substantial evidence of a significant environmental impact under CEQA. Similarly, with respect to the odor and pesticide drift, the appellant relies heavily on generalized studies, modeling critiques, comparisons to projects in other counties. But CEQA requires substantial evidence tied to this project and this site. And importantly, it requires that a significant impact from odor must affect a substantial number of people. The county evaluated the actual context here, a rural agricultural setting with limited nearby residential receptors, and the record does not contain substantial evidence demonstrating that the project would result in significant odor impacts that affect a substantial number of people. As far as the traffic and evacuation issues, the project generates relatively modest traffic volumes. The appellant's argument depends largely on speculative future scenarios involving unrelated projects and hypothetical evacuation conditions. CEQA simply does not require the county to analyze uncertain future infrastructure or worst-case assumptions untethered to substantial evidence. No responsible fire or emergency agency identified a significant impact associated with this project. Ultimately, CEQA does not require an EIR simply because additional study could theoretically be performed or because experts disagree in the abstract. If that were the standard, mitigated negative declarations would effectively cease to exist as a lawful CEQA tool. So the question here is whether the county had substantial evidence supporting its conclusions. It did, and the appellant has not presented substantial evidence demonstrating a reasonable possibility of a significant environmental impact. So for those reasons, we respectfully request that the board deny the appeal and uphold the Planning Commission's approval of the project. Thank you. I'll pass it over to somebody else on the applicant team.
Good afternoon. My name's Erin Cherry. I am the daughter of Jim Comstock and Colleen Comstock. I'm here representing the Comstock family and our family ranch. We have been 84 years at the Coyote Valley Ranch. My dad was born and raised there, as well as myself and my 3 brothers. We all graduated from Middletown High School, and Middletown is our home. I've been lucky enough that I was able to move back, and I am raising my family here. And we love this community, and we love this place, and we hope to be able to remain here for generations. We're lifelong ranchers, and like my grandfather, Hill Comstock, I graduated with a degree in agricultural sciences. As a family, we have always sought to run our ranch in a way that protects the land while allowing for safe and sustainable agriculture. The ranch itself has supported a wide variety of agriculture throughout the years, including sheep, cattle, oat hay, and even pear orchards a long time ago. We see cannabis as the next iteration of sustainable agriculture on our ranch. We feel our project is the perfect candidate for safe, legal cannabis farming. The project location is on a field that has previously been farmed and agricultural for well over 100 years. It is secluded and well removed from the surrounding community, especially Hidden Valley Lake. We have a clear and responsible water use plan. Our plan will not overtax or abuse one of our most precious resources. We have buffers in place from our neighbors in accordance with county guidelines that are well beyond the boundaries of the previous ag that was in those fields. So under the Lake County guidelines, we feel this project is just the perfect candidate for legal cannabis farming. Unfortunately, our neighbor does not see it that way. We have attempted to work with Mr. Luchetti to satisfy his demands, but it has become increasingly clear that he was attempting to use the appeal process not to really address his concerns, but instead to delay or exert an unreasonable amount of control over our ranch and our business. His settlement proposals show he doesn't actually want to prevent cannabis, but rather he wishes to control, regulate, and even govern it personally himself. This isn't just a business for us. The ranch is our home. My husband, my kids, and I are members of the community here, and unlike our neighbor who owns multiple homes across the country and visits Lake County a few times a month, I'm on the ranch virtually every day. I love that land, and I know it very intimately. I could never support any activity that would spoil the natural beauty of what we consider to be our family's heritage. It's very unfortunate we have been unable to reach a settlement with our neighbor on this issue. He will argue that he has repeatedly sought to do so, but in reality, the conditions of his proposals have been unreasonable to a point that it would strip us of our rights as ranchers and as private landowners. Our goal has always been to engage in agriculture that would be the least amount of impact as a way to preserve the natural beauty and ecology of the rest of the valley. Legally, cannabis farming uses less water, has far less environmental impact, and uses less land than other very less regulated agriculture and less economically viable crops. In a time where agriculture in California and Lake County is changing, I saw some of the change driving up today. Many landowners are having to tear out vineyards to the change in agriculture. 40,000 acres have been ripped out statewide in 2025, according to California Farm Bureau Ag Alert. Cannabis is a crop that can be economically viable and allow farming families to continue their land for ag, preserving the rural nature and beauty of our community. We ask that the board deny the appellant's appeal and allow us to go forward with this project. Thank you.
Thank you.
Afternoon. My name is Trey Sherrill, and I am the consultant that worked with the applicant. I want to make myself available for any questions that you may have. I just want to touch on a couple of things that the appellant has stated against this project. To be clear, this use is agricultural in nature and will occur on an ag property in an ag field. The appellant has stated that today that the cultivation area will be 100 feet over the fence. That's the requirement that the county code has, is a 100-foot setback, but the reality is that the canopy areas will be over 250 feet from 276 Ranch. They've also stated that the road that is used to access the property is not 4290 compliant, and that is true. Part of this project would include road improvements to bring the road into compliance with CAL FIRE standards. We have our, and then about the biological surveys, I don't know why the biologists thought that the project area wasn't completely surveyed. There is in the botanical surveys report, there's a map showing all the areas that the biologists surveyed. The surveys that occurred in April and June that area is smaller than the original surveyed area in February, but that was because we used the survey, the biological survey from February to determine where we were going to locate this project on the property. We used information from that survey, and then once we knew where we were going to locate this project, at that point, they didn't survey the larger area. They concentrated on the areas where the project would actually be. The appellant has indicated that they reached out to us to to collaborate on the well testing, and that could not be less true. We had a meeting with the appellant a couple years ago, and I offered that exact same thing. The appellant informed me, we had a meeting with the county staff, and I offered that exact same thing, and they told me straight in my face, like, no, we're not going to do that. And then I've also, in Mr. Crawford's report, he indicated that they reached out, and I have asked Mr. Comstock if they had received any requests to do well testing or collaborate, and he says not once was that offered. We would have jumped at the opportunity. And then finally, we have one of our last people to talk today will be our hydrogeologist, but I just want to make we're talking about levels of significance and in the hydrology analysis, and even the appellant's own hydrologist indicated that theoretically the impact would be less than a foot of drawdown in the worst case scenario from this project. It's in the report that they wrote. Now I'd like to bring up our hydrogeologist to say a little bit about water quality, unless you have any questions about the project itself that I might be able to answer.
Not seeing any at this point.
Thank you very much.
Good afternoon, board. My name's Lee Hurwitz. With Hurwitz Environmental. I'm a certified hydrogeologist. I did the hydrology report, the addendum, and the technical memorandum for this project. And I just wanted to just generally state that the project's groundwater use is considered reasonable. It's supported by field data, and it's not expected to cause significant adverse impacts. The well test that was performed on the project well was only 6 hours, but the appellant also did a transducer study where they pumped their well for 82 consecutive days at 650 gallons per minute, which created a drawdown of about 1.7 feet in a well located about 500 feet away. That's about the same distance as the project well to the Luchetti's well. Yes, do you have a question?
Yeah, I'm sorry. I did see that data in there, but it was a little bit ambiguous. It stated that 87 days, was it 87 days?
It was
But it didn't
82
say
days.
82 days, but it didn't state how long each day it was pumped. Was it an hour? Was it?
I think it was pumped continuously for 82 days, 24 hours a day at 650 gallons a minute.
Wow, okay.
And that created about one.
Hang on,
There was a
you'll get a
couple
chance to,
shutoffs.
hang on.
I believe there may have been a couple shutoffs where they malfunctioned, but my understanding was that's the way.
It wasn't in the report. That's why I was asking. That was one of my questions.
Well,
came
their
up. So I apologize
transducer
for.
study presented that data to you guys, and that was what I responded to when I put this together. So what we found in their study was that they pumped a much higher rate than's being proposed. And the drawdown that they found was 1.7 feet after 82 days in a well 500 feet away. That's about the same distance between the project well and the nearest offsite well. So we could expect that those results would be similar if it was measured on the project well. That supports our conclusion, our initial conclusion. When we did the TICE model, which was the modeling that we did for this project, we showed less than a 3% drawdown in water levels, which was actually more conservative than was actually found when they did their transducer study. So I think that proves that our modeling was appropriate and was conservative. Also, the project well, when pumped, as well as the transducer study that the Luchetti's performed, showed rapid recovery of the wells, which is also inconsistent with regional aquifer stress. That kind of shows that it's a resilient aquifer.
And that was at 650 gallons per minute, you said?
They pumped at 650 gallons a minute. The project well was pumped, I believe, at 350 gallons a minute.
Oh, so yours was 350.
Yeah, and I think that the average pumping rate for the project over the dry season is 60 gallons a minute if it was pumped continuously.
That's the kind of data I needed.
So if it's pumped continuously, the project well would be 60 gallons a minute in comparison to the 650 that was pumped from the Luchetti well during their transducer test. So 10 times greater pumping rate created at 1.7 feet of drawdown, which in our opinion is insignificant. And that's because typically you would see a 10% threshold for significant adverse effects, meaning that the pumping and the project well would have to create a 10% drawdown of available water levels for it to be considered adverse. And in this case, we estimated 3%, and in their study, it showed less than 2%. So any groundwater pumping creates some localized drawdown. But the question is whether that drawdown is significant or adverse. And based on the modeling and the observed field data that was collected by the appellant, the predicted effects and the actual effects are small and below any adverse effect thresholds. And unless you have any questions, that's all I'm prepared to speak about.
What was the recovery? I remember reading it, but just not all the data was in there altogether.
The project well, when it was pumped, tested, I believe it had a 70+% recovery in 40 minutes. And then the appellant's well, when they did their transducer study, I believe had over a 90% recovery in 3 hours.
Yeah, I wasn't worried about their well. I was worried
So
about
it was a
yours.
6-hour test at 355 gallons a minute for the project well, had a 73% recovery in 40 minutes.
But that was only 6 hours.
That was only a 6-hour.
And in the before harvest, when you're in the drought in the summer, when there's the least amount of water, how many hours a day will you be running that pump?
Well, I believe, I don't have the numbers in front of me, but I do know that their average daily project use is 75,000 gallons. So
Okay.
355 gallons a minute was their pumping rate. I don't have it in front of me, but I'm going to guess.
It's just doing the math.
4 to
Okay.
6 hours, something like that, would give them the water they need per day.
Thank you.
60 gallons a minute if it was pumped continuously. Thank you.
Okay, any other public testimony from the applicant's side? Is this testimony your sworn witness?
Yes, I did swear. Yes.
I'm getting a no from the people behind.
Okay, so right now we're hearing are you with the applicants?
No, I'm general public.
Okay,
That's
then
what
if you could
told.
stand by for a minute. Mr. Kasuni, is there any further testimony from the?
No,
the-
Mr. Chair, that would conclude the applicant's testimony.
Okay, so then at this point, we're going to move, I'm not at general public comment for non-sworn witness. Well, you're not a witness in the case, so I'll get to the public comment in a minute, is what I'm trying to say. Is there, at this point, any rebuttal from the appellant that they want to provide as it relates to what's been presented?
Yes, Chair. Ryan Crawford has further comments.
Okay, so he'll provide rebuttal testimony or comment? Okay, we can do that now. Ma'am, if you want to sit down I'll get,
It's hard for me to walk, so.
oh, okay,
It's okay.
okay.
Okay, I think there's a couple things that are important to note. In general, this is like an argument over methodologies, but it's really proving something with your water and your effects of the water. 6 hours of pumping for a project under really no circumstances have I ever done in projects I've done many dozen municipal wells, dozens and dozens of irrigation wells, domestic, every kind you can imagine. Public supply wells, at least, have a standard where you really have to prove you're not going to affect your neighbors adversely. What is that number? I guess we're throwing the number up here is 10% is some theoretical impact, I guess, in this conversation. 24 hours is a basic standard usually for that, to see that at whatever rate you're doing, you're not having a cumulative impact. If Luchettis are already pumping, they already have been pumping, and that's what they've been doing over time, and they've established that. What is the cumulative drawdown with another well going online? There's no actual evidence in a 6-hour pump test. It's a theoretical simulation. There was no measuring of adjacent wells to see what that actually did. It was just one point in one location with drawdown in it. There's a couple of other things to note here. The methodology assumes something called an unconfined condition. So unconfined meaning the groundwater just isn't under pressure at all. It's not confined by anything. It just basically equilibrates to the atmosphere as you pump. However, if you look at all the logs, except for this particular log, which is interesting, but all the other logs in Coyote Valley show 5, 10, 20 or more feet of clay and silt at the surface, semi-confining the groundwater. When a groundwater system is partially confined or fully confined, the actual interference and the effects that go laterally out go much, much farther than an unconfined system. So those are the two main things, really. It was never proven. I didn't, for clarification, reach out to the Comstocks. It just purely was monitoring the wells for the Luchettis, but was told that there was proof that they had, because I requested that. I would love to have collaboration with any other wells nearby. That makes for a much greater study and is actual evidence of interference between two entities. So right now, we don't have that. There is no actual evidence that there isn't going to be material harm to water levels within the Luchetti Ranch. So that's just my opinion, and I'm happy to talk about many of the concepts within that.
Thank you. Is there any other rebuttal?
Thank you.
What was that? Okay,
I'll let Eric go.
okay.
I have a comment.
Okay, Eric, go ahead with any rebuttal related to what was presented.
Thanks. I just wanted to clarify a couple of points. One is that the applicant explained that there has been a pre-construction survey done. I just wanted to say that a pre-construction survey is a mitigation measure. It's not a study that you use for planning. So having that done doesn't replace planning surveys that weren't done. And then the other item was about the survey area. They said they didn't understand why I said that the survey area was not complete. And I glossed over that for time, but to clarify, the reason I said that is that the initial survey area did include all of the access roads, and there's been a lot of talk about access roads. The later surveys did not include any of those access roads. And those access roads are a part of the project, as we've all been talking about. They're an integral part of it, so you can't just gloss over that and say that you've covered the entire project area. Thanks.
Thank you. Mr. Luchetti?
Couple points of clarification. Yeah, sorry. Let me get up here. Okay, a couple of points of clarification, and perhaps the county staff from CDC can clarify and confirm what I'm about to tell you. The Guanac Valley Resort has entered into an agreement with the Comstock Ranch that's been formalized as part of the approval of the resort to use the Guanac Valley Grange Road connector from the Guanac Ranch through the Comstock Ranch to Grange Road, which will touch over part of, not all of, the road that we use to access the ranch, just the beginning of it. That's been formalized in the permit approval for the Guanac Valley Resort, and that is not a matter of speculation, and it isn't a matter of my going out of my mind and saying, oh, I'm imagining something that could happen in the future. It's part of their approval. They couldn't get approval without it. And it was a stipulation of the State Attorney General's office, it was a stipulation of several other parties, and agreed to in the final EIR, the PEIR, the programmatic EIR for the resort, which means we have an unresolved evacuation road that it touches on our ranch roads, including the Comstock roads, where the combined impact of everything, evacuating the 40 cars a day at peak summer, the Luchetti's going in and out, Comstock's going in and out. Coast Guard's not currently in use, but y'all just suggested it should go to the tribe and may soon be in use by the tribe. Going to the Noise Ranch, all go over these roads, and these matters have not been resolved in a cumulative impact study, which is required by CEQA. This isn't my imagination. This isn't speculation. It's factual. And it's based on what's been approved in that PEIR. Now, I'd like CDC to verify that.
Sir, you need to address the board.
I'd like the board to ask CDC to verify what I just said. It has been approved in the Gwinnett Valley PEIR.
Okay, the board will, I'll direct.
I'm asking.
Okay. All right, that's your comment at this point?
Well, I haven't made all my comments. I have some more comments.
Okay, go ahead and finish your.
To make. Okay. After the drought of 1976 and 1977, we used to pump, we have the senior-most water right in the basin. We have a 320 acre-feet water right to pump out of Pewter Creek. When we first came to the area in the 1960s, you could irrigate our pasture, 110 acres of irrigated pasture, from that water right. Over time, as in my opinion, Hidden Valley started to get built out. People poked more holes in the ground, more wells were put in place, and I also personally believe there has been some form of climate change. You can no longer get through an irrigation season pumping out of the creek. You have to pump out of wells. The tipping point was the drought of 76 and 77, which was the first part of this the change in the water resource availability in the area. And that's when we drilled 2 wells, 500 feet apart, each producing 650 to 700 gallons a minute. And when the Pewter Creek well pump that we used to pump out of Pewter Creek, when we run the course on that, and the water in the creek's not sufficient to run the pump, it's about 2,500 gallons a minute, we turn it off and we go to the wells. From the beginning, in 76 and 77, in dry years, our 2 wells, which have automatic pump shut-off safety devices on them to preserve the wells if there's shortage of water, if you're pumping in a dry year, one will shut the other off. This has been true since the 1970s, consistently, and particularly troublesome in the last number of years where we had a lot of drought years, and from the Valley Fire to present. If you run in a dry year, our 2 wells shut each other off. You add another well 500 feet away, that's going to shut off. So this is not my imagination. This is factually what we're experiencing in our field conditions. This is what's really going on. And then the last thing I'd like to say is I do appreciate Erin Cherry's comment very much, and I want to tell the board, I agree with her. We both love that valley and that environment and support that environment. This isn't an indictment of their growing cannabis. These are questions about how their project could affect the viability of our organic beef production business and our quality of life in the valley. And there are details that need to be resolved. It's not an indictment of what they're trying to do or a statement that we cannot work it out and figure out how to solve these problems. I just want to make that clear. Thank you.
Thank you, Mr. Luchetti. Now, at this point, does CDD have any rebuttal?
Thank you. During the review process, the Fire District, CAL FIRE, and Lake Office of Emergency Services expressed no concern regarding this road. As the board is well aware, the road will serve as an option for evacuation should there be a needed evacuation from the Gwinnett Valley project in the years when it does get to full size. It's an option, it's not an assumed, because there are so many criteria that are evaluated by our first responders to pick the safest evacuation route. And so because it is that slim, it does not count as a daily road trip that would establish a level of, or hit the threshold of significance in CEQA, which would require a traffic study. So no traffic study was required.
Okay. Any other rebuttal regarding this matter from CD?
We do not typically require biological surveys on existing roads that already get traffic for other purposes. We do require biological studies to cover the project where those impacts would be.
Okay. So that would conclude.
Additionally, the appellant's biologist made reference to the studies being so old. This project has been in the works for a number of years.
Can I take a time for a second?
One you can, a break.
Okay. We're
And
gonna.
we do not require additional biological surveys once the project is under review.
Okay.
Thank you.
All right. And we still, I know we need to take a break. How many additional folks are here for public comment? So we've got 1, 2, 3, 4, 5, I believe.
6.
6. So we're going to take a short break at this point.
5 minutes.
Try to take 5 minutes. Thank you. All right, I'm going to call our meeting back to order. And before I go to public comment, I just want to confirm from both the appellant and the staff that any sworn witnesses that you had that you wanted to provide sworn testimony have had an opportunity to do that. Correct on the appellant's side? Staff, you've had an opportunity to present anything? Okay, so with that being resolved, we're going to open it up to public comment, and these comments are going to be restricted to 3 minutes on the public comment. And I know we have 6 people. Ma'am, did you want to go first? Okay. So you'll state your name for the record, and you'll have 3 minutes. Johanna, if you could start the timer.
So my name is Glennis Dunbar. I live about 4 miles south of Middletown on a dirt road of private easements. And I'm not here to support cannabis. I don't support it. I don't think it's a good thing. However, I want to share my own experience with living next to both legal and illegal grows. And we've had illegal grows from one about 200 feet from our house, the other about half a mile away. And during that time, there was lots of traffic on the road that goes through our property, of lots of people that you never saw again, whether they were coming to buy or they were seasonally coming to work. And a lot of them were rather sketchy looking folks that just kind of passed through, which is not a comfortable feeling as a property owner. We had concerns about pesticides getting into the year-round stream, and other kinds of worries, which we don't have anymore. Just sort of, you wake up one morning and notice you're not thinking about those things anymore. There's very limited traffic. They're consistent people. You don't necessarily become friends with them, but you don't worry about them because they come all the time. In terms of odor, we did have problems with the grow 200 feet away that was illegal. They are since gone. They didn't choose to legalize. And the grow that's about a half a mile away, we never smell. And part of the consideration around odor, I think, has to do with wind direction. And certainly for us, the wind comes out of the west. I don't know that that's true everywhere in Lake County, but because of that, I think the wind is our helper, and the odor risk is much less than I ever would have guessed. So we experience no odor from a much larger grow than we had before. And I guess the other thing I would say is that ranches, both like the Luchettis and the Comstocks, are endangered species these days. This is very challenging for a family to work together to sustain a property over time. And what is often happening is those same ranches, the offspring aren't interested, they can't, or the financials aren't there, and they end up selling them, and that whole way of life goes away.
Okay, thank you, ma'am. Next person in the room. State your name for the record. You'll have 3 minutes.
Good afternoon, Board. Tom Lasik. I just want to touch on one aspect of this, and that is the road safety and safety in general. The staff presented the internal roads. There was one of the concerns is that there is a bridge there that has to be crossed, and it needs to be rated for, I think, 75,000 pounds. I'm not sure if that has been discussed. I'm also concerned with what I would call not really a clear answer. I'm sure the fire district did not respond with an inspection, but to assume that that was somehow a sufficient review of the safety, I think is not quite accurate. The main thing I do want to point out, though, and spend most of my time on, is the lack of a safety study. This happens repeatedly. CDD refers to, and the document they refer to when they talk about meeting the 110 VMT threshold is called the Technical Advisory on Evaluating Transportation Impacts in CEQA, which comes from the California Department of OPR. And that document does have advisories for evaluating transportation impacts of CEQA, but it's for air pollution. It's for greenhouse gas emissions. It's for where to put bus stops and bike lanes to reduce our carbon footprint. It's not meant to evaluate safety. And in fact, within that document, I think it's section G, it very specifically says don't use this document as an evaluation for safety, and that you should use other documents. Now, that document came out in 2018, and since then, Caltrans has put out other documents that basically say you need to consider safety. And unfortunately, this has been a categorical boilerplate document. If you look at any M&D for the last 5-6 years, you'll see almost the exact same language over and over and over again, referring to this document as a reason not to do a safety study. And so they're using the wrong document the wrong way for the wrong reasons. And we are talking about evacuation for simultaneous ingress and egress of responders at the same time. People do need to evacuate. It wasn't studied. It is a dead-end road, which is a 4290 concern. They do not evaluate roads outside the property, which is not supposed to be the way that's interpreted. And as has been mentioned already, it's not wide enough. So I'm just concerned that there hasn't been the study. And thank you for your time.
Thank you. Next person for public comment.
Good afternoon. I am Robert Hall. I've been a resident of Lake County for 53 years. I own 75 acres, 4.5 miles south of Middletown. I've known Comstocks for the time I lived here. He's a great public servant. So on our road, we had 2 illegal grows, one to the east and one to the west. The one to the east, the fellow solved the problem by dying. It ended his career. The one to the west was continued to be illegal. And then one day, 6 fish and game vehicles, the sheriff, another 1 or 2 came roaring in, put him in handcuffs, and stopped his operation. He learned his lesson. He became legal. His property is within 200 yards of mine. And he's been a great neighbor the whole time. Odor was never an issue. Water was never an issue. Before he was legal, we used to have the itinerant cleaners to come in and clean up his crop. There are all kinds of vehicles going in and out day and night. all that ended when it became legal. So I encourage the board to deny the appeal and let the process go forward so Comstocks can put their crop in and generate some revenue for their property. So what's worse? Another thing that's happening out in, I don't even know the name of it, where this development is pending. You want to see Comstock take its 1,600 acres and add a golf course or two and condominiums and hotels and all that stuff? I'd say no, that would really ruin the character of our country or our county. So you have a case where Comstocks have been here their entire life, multiple lives. And you have some other people that have multiple properties that don't have the investment in this community that the Comstocks do. Comstock was 2 terms as supervisor here, did a great job. So I encourage the board to deny the appeal and allow the process to go forward and grant him a general use permit to grow some cannabis. And thank you.
Thank you, sir. Next person.
How you doing? My name's Robert Loudermilk. I've known the Comstocks since the early 60s. Went to school with Jim and his wife Colleen. The cannabis deal, if that's what they want to do, if they're doing it legally, I can't see why anybody would want to stop them. I have nothing but confidence in Jim. The water issue, we've owned property, my family, on Pewter Creek since 1960. At no year have I ever not been able to go out there, dig down 18 inches and find water. So I guess I'm befuddled by the experts, but you know, maybe they know more than I do. Anyway, I'm just in Jim Comstock's corner.
Thank you, sir. Next person. Did we have more? Not seeing any more. Do we have anyone online? Or ma'am, come up. No, I want to finish in the room and then.
Hello, Chair and Board. My name is Sarah Bodner, and I'm a land use consultant that has worked on dozens of projects throughout Northern California since legalization occurred. I've had the pleasure of working with the Comstock family and Ned during the last 5 years on their journey on this project. Through my work, I've encountered difficult, complicated, and controversial projects that have required many delays, modifications, and compromise. So I'm no stranger to the dance that legalization has presented and the struggle of it. I said yes to working on the Rancho Lake project because it was not difficult or complicated. It was the ideal application. A local family and farming partner committed to the land and this county. Flat, previously disturbed ag land with abundant water, and a thoughtful and ecologically minded farm plan located in a low-density valley with few neighboring residences. This project checks every box, meets all local and state regulations, and has been studied and monitored by stand-up environmental specialists. If this use permit were just about land use policy or the smell of skunks in the country, it would be a straightforward, fast-tracked yes. However, it took this long not because of any issues or flaws with the project itself, but because it was submitted at a really crowded time. It was in a long queue of projects, and the use permit over time was handled by multiple county staff due to changes in turnover here. Personally, I stayed with it over the years because it's one of the good ones, and because this county staff team demonstrated its commitment to giving it fair consideration and following the due process. Thank you to the Community Development Department for that. When the use permit finally moved through the county's due process, it was a resounding yes from staff and from the Planning Commission. The only true opposition is from one man who has not found purchase with a single one of his claims about the violation of the land use policies or its impacts. So he's lobbied false claims about the project, bad faith arguments, and untruths about his own organic certifications for one purpose, to stall a verdict that he simply doesn't want. He's done everything he can and exhausted public resources to try to stop this project from reaching its due approval, and he's run out of options. His goal is trying to control what his neighbors do with their property and how they do it. But this is America, and if there's one thing we have the right to, it's the freedom to pursue the use of private property that follows the laws of this land. To that end, I respectfully ask that this board support the findings of staff and the Planning Commission and every agency consulted, and deny this baseless appeal and say yes to the Rancho Lake use permit. Thank you.
Thank you. Was there anyone else in the room? State your name for the record. You'll have 3 minutes.
Good afternoon, Chair and Supervisors. My name is Ned Fussell. I'm the operator and co-applicant for Rancho Lake LLC. I am one of the original founders of CannaCraft, a cannabis business in Santa Rosa that employs over 400 union employees throughout the state, from Santa Rosa to San Diego. We manufacture and distribute to over 600 licensed dispensaries around the state. I want to start by stating that cannabis is a plant medicine, and now with the new rescheduling on the federal level, in the coming years, cannabis will be regulated through the FDA as medicine. For over 10 years, we have manufactured and produced medical products for hundreds of thousands of patients around the state, from everything from childhood epilepsy, cancer patients, to folks dealing with different types of pain and inflammation. For reference, over 50% of the raw material my company has utilized to make this medicine has come from Lake County. While I have started many businesses, you will not often find me in my office. My heart is deeply rooted in the agriculture, and I am by trade a farmer. Cannabis just happens to be one of those things we farm along with food. In 2021, I met the Comstocks, and they shared with me the rich history of their ranch, which has been in their family since 1942. They've implemented many forms of agriculture and livestock over the years. Some have been successful, others haven't. As with anything in ag and often business, your ability to pivot and adapt to markets is essential to your survival. This is a 1,627-acre ranch proposing 19.5 acres of cannabis cultivation. That is roughly 1.2% of the total land mass. The other 98% remains open ranch land, wildlife habitat, and grazing land. To me, that essentially makes this property a nature reserve owned by a single family that has cared for it for almost 100 years. Nobody cares more about the land and its inhabitants than the Comstocks. The land is ideal for farming. It's located on existing ag with no new land disturbance taking place. Years of environmental review, studies, and redesigns and conditions have already gone into this process. History is important. Families that have served this community for generations matter. Keeping this land intact and out of developers' hands personally matters to me. 5 years have gone into getting this project to this point. I have operated many acres of farms in this county for the past 5 years and have contributed millions of dollars in tax revenue to this county specifically. I hope to continue to operate here for many years into the future for the same reason that the Comstocks came here in 1942, to build something viable that can be passed down to the next generation. Thank you for your time.
Thank you. Was there anyone else in the room? Not seeing any. We're going to, okay, one more.
Good afternoon, Chair, Supervisors, Margot Kambara. This appeal stirs up a lot of emotion, and we see how it affects families. We see how it affects important sector of our community, the ag community. But what's before your board is an appeal, and that appeal is on grounds of CEQA. So that means your board, with respect, needs to look at it in terms of CEQA, violations of, or shall we say, insufficiencies in the studies, insufficiencies in the reports. And this is not to say that they can't be remedied, but right now it would be premature to approve the project when the data is old. For example, it has been brought to your attention that these studies, the biological studies, are at least 5 years old. That poses a problem, especially when Director Turner has told the General Plan Advisory Committee in one of our meetings that reports, when it comes to evaluating environmental impacts, should be no older than 5 years old. I'd also like to bring to your attention CEQA section 15384 on substantial evidence. And I will try to spare you the dryness of it and just highlight what's important to this appeal. And that is, CEQA tells us substantial evidence, quote, is enough relevant information and reasonable inferences from this information that a fair argument can be made to support a conclusion, even though other conclusions might be reached. Whether a fair argument can be made that the project may have a significant effect on the environment, it is to be determined by examining the whole record before the lead agency, and that's CDD. So let's continue on. What about this substantial evidence? Quote, substantial evidence shall include facts, reasonable assumptions, predicated upon facts, and expert opinion supported by the facts. End quote. And that's precisely what the Appellant team has done. Thank you.
Thank you. Was there anyone else in the room? I don't believe so. Okay, online, Johanna? Autumn, if you could go ahead, you'll have 3 minutes.
Hello, can you hear me?
Yes, we can. Go ahead.
Great, thank you. Good afternoon, board and chair. My name is Autumn Carsey. I'm a local resident and business owner. Over the last few years, I've gotten to know the Comstock family, and I can confidently say they operate with integrity, they care deeply about this county, and they have a genuine stewardship for the land spanning almost 100 years. Ned Bucell is a well-respected entrepreneur who has helped build some of California's most recognizable cannabis brands. But more importantly than any brand or business accomplishment, Ned is a farmer who believes deeply in agriculture, community, and preserving working lands. I have reviewed the application materials and I have personally visited the Comstock Ranch. To see this property in person is to understand how ideal it is for cultivation. This is a working ranch with a long agricultural history. This matters because once families can no longer keep large agricultural properties economically viable, eventually those lands get divided, sold off, or developed. Families like the Comstocks are a part of the fabric of Lake County, and keeping ranches like this intact matters for the future of this community. This project has now gone through 5 years of studies, redesigns, environmental review, hearings, and substantial investment to comply with the county's process and CEQA requirements. The county's own staff report confirms the project exceeds setback requirements, requires no new tree removal, and includes extensive environmental protections and mitigation measures. I also want to address the concerns regarding neighboring cattle operations. This is a licensed and highly regulated agricultural operation, governed by California's pesticide, environmental, and water quality laws. There is no specific regulatory basis establishing that a properly operated cannabis farm can inherently harm neighboring livestock simply by existing nearby. Lake County has always evolved through agriculture, from pears to walnuts to wine grapes. Each generation has adapted in order to survive. Right now, we are watching vineyards across California being pulled out at historic rates, with experts projecting more than 100,000 acres could ultimately be removed statewide. Agriculture changes. The families and communities that survive are the ones that are willing to adapt. Cannabis is simply the next chapter of that agricultural story. At the end of the day, I believe this decision is about whether Lake County stands behind families, agriculture, and the integrity of its own process after 5 years of work. I thank you for your time and consideration, and I hope that you move to approve this project. Thank you.
Thank you. Do we have anyone else? Okay, I'm going to close the public comment and bring it back to the board for any staff questions or comments, consideration, action, et cetera. We'll start with Supervisor Owen.
Well, first I'd like to, I guess I better turn on my mic, sorry. First, I'd like to say that this is really unfortunate that this project has divided and strained the long-term relationship between these two families. I've known both of them pretty much all of my life. I used to babysit Mr. Comstock's sister at his house, at his current house. So I've known them forever. My mother and his father were great friends. I've known Peter for many, many years. So I'm really sad that this has came to that. I'm hoping that we can find some kind of way that this can work and move forward, where both parties can give a little and both parties can still achieve what they need to achieve. I was actually raised on Grange Road. I do have some concerns about the what I feel is probably a little bit of an inadequate well study, not that it can't be redone, and to calm those fears, but 6 hours. I do know that when I lived on Grange Road, we had a hand-dug well of 28 feet. When Hidden Valley Lake started drilling on the south side of Pewter Creek, it dropped the water table and we had to drill another well. So that's a fact, and it was quite a ways from our well, like probably a quarter of a mile, and they drilled 3 wells. So, it would be nice to kind of, I don't think it'd be that expensive to really do another well test and make sure that it's sufficient to calm the worries in that issue on water. The 4290 road requirements, I believe that it was mentioned that you were bringing those up to code when it was coming in, which I think was an issue once you start doing the drying, the processing, and the packing at the facilities. I think that's, as I understand it, should come up to the 4290. The only question is the bridge going across, and that might need some improvements, maybe some widening, I'm not sure, but if it comes to 4290, I think that could work. I'm unclear on that, if that's what was said earlier. I think that was one of my questions. The cost of the pesticide drift. This is something that actually Mr. Luchetti is going to have to address for me. I am wondering, there's a difference in cost of your meat and the value of your product if you have organic or if you don't raise organic. You get a much higher price, you know that at the grocery store when you go in and you buy something organic, it's more expensive. And I don't know that is sufficient. That is why I know that I believe Mr. Luchetti had asked for the FPZ zoning change. And that would have just pushed their project back further from where it was. And I know that those old hayfields, I used to lope horses in those hayfields. And I know that there's plenty of room to do that if it would work. As far as moving the project back far enough to have the clearance to not affect the pesticide drifts that may occur, and they're going to occur. To say that you can't, to guarantee that, if it's going to affect his certification for organic, it's going to cost him money, and it's not going to be cheap. And then it's going to take many years, I would think, to get that certification back. So not saying that no on the project, absolutely not saying no, just say, can we locate it back further so that it does not affect the drift, doesn't affect the organic beef. Like I said, I'm not sure how much more per pound you get on your beef that you raise at the market for organic versus non-organic. So those are my comments that I've noticed in this.
Okay, any other board members at this point? I've got one question about just for clarification, so as I understand, the emergency evacuation onto this road from Gwinnett would be a third option that they would have once that's built out for an emergency, because they're still going to have two of their own
No, they only have.
access roads?
That's Canyon. And this one.
I'd have to actually go back and take a look at that. I don't know offhand. I believe that is accurate, but I'm not positive. So
Okay, because I seem to recall that they were having to build out another road in a different direction, but is that,
And there's two exits.
yes,
Two exits of the project, but they're all both on Bud's Canyon.
Yeah,
The
Bud's
other one is
Canyon.
Grange.
Yeah,
Right.
that's it.
okay, all right,
Just got that little horseshoe where you can go into where the village will be, or you can go where the winery currently is.
You can go right or left.
okay. All right, and I believe I did hear information presented that there was some statements about the Rancho Lake possibly doing some improvements on that road. I thought I heard in the testimony, but go ahead, Supervisor Sabati.
I'm going to say something that might be offensive to some. This is a conversation of absolute privilege where even with close to 1,000 acres, you can't live too close where you can't figure it out. Like it's frustrating. Like we deal with code enforcement where people are stuck in a 50 by 100 lot, and yet here we're talking about hundreds and thousands of acres, and we can't find a way to have good neighborly situations where there's an appeal, there's a petition at the courts. Like it's a little frustrating from my perspective in this county that deals with so much struggle that this is the conversation that takes up this much time. Pesticide drift is illegal. You are not supposed to have drift. And so that's it. And if there is, there's ramifications for that, both from us as pesticide control, I believe through the Ag Commissioner, and as anybody who is impacted by a neighbor or another person, what they do to them, there's remedies for that as well. So I don't think we should be making decisions on something that is already illegal. So I think that one, to me, I throw that one out the window. The water was a concern. I didn't hear substantive evidence to say that here's proof that it will have negative impact. All I really heard was sowing of doubt that it could have impact. And I don't think that's enough to make that change. And when you go from hay and oats to cannabis, it has a lot of similarities in the amount of water use. And I know we've been through that conversation before with the property over on Augulin Canyon in the past. And so I just, the roads, it's already in the conditions of approval that it needs to meet 4290. I'm also looking forward to the road in general. I doubt that the Attorney General was anticipating a dirt trail as an evacuation pathway, so I'm sure it will be built out as well, which will help as a whole. I don't see any health and safety issues. What I do not like, and this is my only problem that I really have with the project, is outdoor cultivation in an appropriate area, but to me, the harshest, most, and I guess this is a way that I'm looking to see if we can find a compromise. The harshest situation in any point of a harvest is when you're drying. And what I'm seeing is a drying shed, which is a temporary building that has no air filtration, no nothing. And I guess I would prefer looking for something a bit more permanent that can help out in the area, that can filter out the smell so that it doesn't have an impact on the neighbors. Because when it's growing, it's really kind of faint. It's really kind of not as bad as when it's drying. That's when it really gets intense. So is that a possibility? Because right now you have 6 buildings, I believe, that you are planning to put on the northern edge of the cultivation for drying. And I mean, it's got some large distances from it. It's over 1,000 feet away. But I guess that's the only part to me that maybe that could be helpful. Is that something that can be phased in so that it gets better and better as the years go on? But overall, I mean, it's ag. We've been talking, we haven't finalized, but we've been talking about setbacks. We said ag, that's what it's for. It's for dirty work, it's for smelly work. I think the project is in a good location. I think the conditions of approval meet it. If there was anywhere to compromise, it would be how the drying is being planned to see if it's possible to minimize the potential smells, which again, more than 1,000 feet away. I had to find something to see if there was anywhere to be able to meet halfway, but I'm not seeing it. Now, I know there's been a couple of things being lobbed, and I guess if you didn't know, maybe you didn't know, but you are also under oath. I did check, and I did find a certification for organic. And so I've heard a lot of statements. I've read a lot of statements that say otherwise. Sometimes you got to go to the source, and I was able to find something. And so I would love for you to continue to do what you've been doing. You have a large amount of land to be able to make that happen. And I also don't want anyone telling their neighbor how to utilize their own land. We have laws, we have regulations, and your project fits within those laws and those regulations. And I hope that things get easier as we go into the future, where we're a little bit more accepting of allowing people to just farm their land and choose the crop they wish to use. And those are my comments.
Vice Chair.
I don't have much more to add other than, we do want to protect agriculture in this county, and this is agriculture on agriculture lands. This is a great project. It's very well planned. It's been taken a long time to get through the process. That's what's really unfortunate. But I have no issues with this project, and I would really like to see it move forward.
Supervisor Owen.
I had left one little thing out, but I need to first push back on my my friend here. The type of hay that they were growing, notoriously, the only type they've ever grown that I know of, is a dryland crop, which means the rains come in, they do not water it. If they were planting alfalfa, you'd have an argument. That wasn't the case. So
So you mean weeds?
With oats. The next thing is, I would still feel better if we could have a little more information on the water, and I don't think that would be a huge ask. And then I feel as Mr. Bruno feels on the fire safety on the drying, processing, and packing facilities. I don't know what the state requirements are on those, but I'd like to make sure that they are to standard. I believe they're supposed to have fire suppression, sprinklers maybe, I'm not sure. So just making sure that we're to code on that, because I wasn't sure if they were going completely where they were going to take them down, if they would have all of the requirements. And then the only other ask I would have that would really put the cherry on top would be, I know that drift is illegal, but that doesn't mean it doesn't happen. So I would still I'd wonder if there was any reparations or anything if it did end up affecting the organic certification. That was, I know, a huge issue for Mr. Luchetti, was the organic certification and not wanting to risk that. So then I would be absolutely behind it. We just need to make sure that our I's are dotted and our T's are crossed. Thank you.
Anything else from the board at this point? And I think we're potentially ready for action.
Would you be able to respond on the building and the fire safety stuff?
Yes, I can. The building would require a building permit for a temporary structure, and that would meet all of the California Building Code requirements. The purpose of these structures is to not permanently damage ag lands by having permanent structures on them, and to be able to deconstruct those after the season and not create any impermeable surfaces. But the buildings themselves, the temporary structures, would be put up to standard for California Building Code and would meet those requirements and have a building inspector final the inspection prior to occupancy.
Okay, so that means you wouldn't have a floor in it, so you don't have to put the concrete down, which is awesome. And then what about the fire safety aspects of it and ventilation?
Sure. So sprinklers are required for an F1 occupancy, and that is for 12,000 square feet or greater of a new surface. And that does not meet these requirements. It would have to be one building meeting 12,000 square feet or greater for sprinklers. However, the project does include water dedicated to fire suppression and will be equipped with the standpipes for the fire district's connection and water on reserve specifically for defensible space and things like that.
And these are only 6,000 square feet, correct?
Yes, there are 5 structures that are 6,000 square feet each.
Supervisor Crandall?
Yeah, I just figured I'd say this. I read the report or the actual planning commission. I watched the video, and I want to support the planning commission. I want to support this project. I figured I'd just say that because you all were looking at me like, where do you stand? So I figured I'd just say it.
How'd you know?
All right, that answer your question?
Yeah, no, I appreciate it.
So I think we're ready for some possible action.
Right now, I can't without further water information. If they're not going to commit to further water testing, I can't support it without that. Without the further water testing. It'll pass without me, but.
But I know it's 6 o'clock. There's annual water reports. That's part of their process. So it would give us a context of what's going on with their water, correct?
Yes, that is correct. We do receive annual progress reports during our annual compliance monitoring, and those are due to the department by June 1st of each year.
And does that give you the static level, and is it possible to, I mean, I guess what difference would it make if we run a test? Do we cancel the permit if it doesn't go through? Like, I just trying to figure out how that information can continue to come to us, because I know that we get the annual report. I guess I'll stop talking. That's. I just wanted to make that clear that we do continue getting information.
If it affects Mr. Luchetti's wells in a negative and draws him down too much, what is it, 10% or whatever, is that also evidence that there wasn't enough? How is that handled if it negatively? Because like I said, on Grange Road, we lost our well.
We do not have requirements for annual impacts on offsite wells. We do hold them accountable to using the amount of water that they stated they were going to use, but offsite impacts, the reason why we hold them to the amount that they say they're going to use is because we have the hydrology reports that say that this will not cause the negative impact to the offsite neighbors. And so that's what we do is.
Right, and I felt that that it was insufficient, the hydrology report. A 6-hour hydrology report I felt was insufficient. And like I said, personal experience on that road, we lost our well. So that's why I'm going to stand harder on the water.
Understood. We do not have it in our code to monitor water use for offsite impacts.
Mm-hmm.
Okay. Do we have any proposed motions?
Yeah.
If I could just add one more thing, we also
ahead.
do not have monitoring of what offsite water uses are over there too.
No, they
in order
have-
to connect the sort of impacts.
Well, I think that there's a lot of monitoring going on in the valley where, so that they can find out if their wells are affected. That's what I'm saying. If you could use their data.
Right. We did have that report from Vector Control regarding the flooding of the pasture next door as well. And so that's the type of water use that I'm talking about. You know, we don't control, there is no authority to oversee water use per property by the property owner.
County Council?
Yeah, so Chair, if it's if it's your will of the board, I do, well, it's here on the sample motion on the board memo that was made a part of the agenda packet. Just want to add to that a bit, just to provide justifications as is standard practice for purposes of that motion. So when your board is ready, I could just state that for
We're ready.
your board's proposal. So, okay, so the motion would be move that the Board of Supervisors deny appeal PL-26-12, upholding the Planning Commission's approval of major use permit PL-25-13 for UP 21-15, and adoption of initial study IS 21-13, and that would be based on the findings made on page 17 through 21 of the December 11, 2025 staff report, which is exhibit, I believe, A1, and page 3 to 4 of the January 8, 2026 staff report, which is exhibit A, and direct staff to prepare draft findings of fact.
I just want to correct that with initial study 2313, and so moved.
Second.
So I have a motion and a second. All in favor?
Aye.
Aye. Opposed?
Nay.
That motion carries 4-1.
Do we need to make any motion about when the findings come back, or does it just happen naturally?
Correct, that would be pursuant to the zoning ordinance. Typically, I believe it's a 45-day period.
Yes, it was 45 days.
It would be agendized.
Yeah.
Okay.
Okay, that concludes this item.